Why is it so quiet here? Okay.
We'll just give Advocate Kleinhans a few seconds to join.
Okay, no, thank you.
Yes. Yeah. He is so.
No problem.
He said to me, join. Oh, okay. He just had to restart his computer. He just sent me a message now. So let's just give him a minute or two. I was just going to speak when you spoke. Okay, I just see the WhatsApp message came through now. So let's just give him a minute or two. Yeah.
You're welcome.
So we're just waiting for someone.
We're waiting for the facilitator. He just had to reboot.
Oh, okay. Thank you very much.
That's just yeah. Your facilitator's Advocate Kleinhans. Owen. Okay, so we just wait for you. He just sent me a message.
Claudine, I'm here.
He's there. Okay.
Okay.
Oh, you know, these lawyers, they're very over time. I hope they can always be on time for all their court sessions. Okay, everybody have a good session. Bye.
Thank you. Welcome, everybody. Before I start, are there any questions related to last week's discussion? Any comments? Anything you are unsure about? Pose your question now. You either unmute your mic and pose the question, or you put it into the chat function. Okay, so if there's no questions, I want us to go to page 65, okay? Okay, all of us in the course reader, go to page 65, please. Okay, and last week, we started the discussion on logic and legal arguments, okay? And we stated that logic, the term logic, okay, was important to us as law students, as legal practitioners. Why? Because it enhances our ability to solve problems. Okay? It enhances our ability to solve problems, and we stated that logic is the study of rational thinking. Lawyers are people, we are differently wired, we think differently, okay, because in order to find a solution to a legal dispute, we need to approach things in a rational manner. So logic can thus be said, I'm on page 65, paragraph 3 of page 65, and it tells us that logic tells us, Nadia, I'm going to come to your question now. It tells us that logic can thus be said to be the study of rational of rational thinking, and it is concerned with the structure of valid arguments. Now, students, when I refer to valid arguments, what does that mean in a legal context? What does it mean when I refer to valid arguments? What does that mean in a legal context? Anyone?
Okay, can I respond, Professor?
Who is this?
It's
Tell me your name.
Lucas. It's Lucas. The surname is Kopi, Professor. And
Lucas, where are you from?
I'm in Kraaifontein, Wallasdien,
Okay.
Cape Town. Yes.
Okay.
Yes.
You have a response for me?
Yeah, I think the response when we talk about a valid argument, can I actually refer, if for instance you are arguing a case, everything must always be consistent and it must never be out of the scope of the argument which is taking place within a case. I'm just actually now thinking, yeah, I'm trying. I think when you talk about a valid argument, it must something which must never be out of the communication or which is taking place in court. So
No,
everything must be valid.
No, you're not telling me what a valid argument is.
Okay.
I don't know what you mean by that response. You want to try again?
Okay. Okay, let me make an example. Isn't it, for instance, we are dealing, for instance, just speaking under correction, we're dealing maybe with a rape case. As we're speaking with a rape case, you are arguing as a lawyer there because somebody must be put in jail. You can't get out of the topic and make it perhaps something which is change the case and say maybe into stealing while the topic is about the race. I'm just now trying, yes,
No,
but if I'm out of the way, you can actually rectify me.
You are very out of the way. Okay, so get your pen and your notepad ready and starting notes when I start giving a response. Okay, thank you, Lucas.
Pleasure, sir.
Okay, Lucas, just switch off your mic, okay? Okay, anyone else? We listen to Lucas's response. Are there any other responses? What do we mean when we speak of valid arguments? Denzel, you're giving me something that's in the book. Nee? I said, give me something, the meaning of a valid argument in a legal context. Anyone, people, you are future lawyers. This is a very simple question. You need to ask it again. What would you say is a valid argument in a legal context? Nadia, no, the argument doesn't have to be true. No, Michelle. Anyone else? Come, people. Palisa, no. Who else is there? Let me see. Sipo, where's Stefan? Stefan always talks to me. Stefan, what is a valid argument?
Hi there, it's Stefan here. Mine was in the chat, but I said pertinent to the case and provable.
No. Anyone else? People, it's very simple. You're going to kick yourself.
Okay. Can I make it try?
Okay. Yes, sir.
Valid arguments.
Yes.
Yes, please. Where the premise and the conclusion relate with one another.
No, you're not telling me what the valid argument is. No.
Okay.
No. People. No, Nadia. Thank you, Karabo. Karabo, you win the prize. Thank you, Karabo. Okay? It is an argument based on the law. Okay? So when we argue, we base our arguments on the law. And who can tell me what source of law do we base it on? People? Thank you, Karabo, for that. I'm impressed with you. Okay, so a valid argument, students, should be based on the law. Okay, and thank you, Perez. Okay, our arguments, valid arguments, should be based on sources of law. Okay, may it be primary or secondary sources. Thank you. Can I continue now? Okay. So when we argue rationally, okay? And we base that rationality on the law, okay? Any other questions or comments before I continue? Any other questions or comments before I continue? Okay. So, we concluded by saying that logic is thus the study of rational thinking, and it concerns itself with valid arguments. Okay? And we looked at what an argument is. Okay? We looked at what an argument is, and we know now that an argument is a network of statements in which one statement is made on the strength of another. And here we the one statement, the garden is wet. The second statement, because it rains. Okay? So, we now know that an argument, okay, with a ground or reason, okay, an argument which has a reason or a grounding, okay, is known as a premise, or we call it a premise, and from there we can draw a conclusion. Okay? So what we must know is that a premise leads to a conclusion. And what we looked at first was deductive reasoning. And in terms of this kind of argument, okay, we say that the premise forces the conclusion on us. Okay, the premise forces the conclusion on us, and we took the example on page 66, the example of a rape matter. Okay, we took the example of a rape matter. Okay, and we looked at And we looked in that example, we looked at, let me just see where I am now. We looked at premise number 1, which was the semen sample. We looked at premise number 2, semen sample B. We looked at premise number 3, the DNA of sample A. We looked at premise 4. It's impossible for 2 different people to have the identical DNA. We looked at premise 5. Both sample A and B came from the accused, and the conclusion we drew, okay? The conclusion we drew is not, remember this is a rape matter, the conclusion we drew is not Abel raped Barbara, okay? We cannot draw that conclusion. The conclusion we drew is that they had sexual intercourse. Okay? The conclusion we drew is that they had sexual intercourse. Okay? Let me just go a bit further with this example. In terms of arguing, students, in terms of arguing this rape matter, what must the state, what aspect relating to the sexual intercourse must the state now prove? Any ideas on that? Okay. From the deductive reasoning, we came to the conclusion that Abel and Barbara had sex with each other. Okay. Michelle, very good. The question of consent. Michelle, very good. The question of consent. Okay, Denzel also gave that answer, Nadia gave the answer, and Sipo gave the answer. So we have a few prosecutors amongst us. We have a few prosecutors amongst us. Can I ask if there's any other comments or questions before I continue? Any other questions or comments before I continue? Okay. Any other questions before I continue? If there's no questions, then I'm going to continue. Okay. If there's no questions, I'm going to continue. Okay. Just one announcement. I'm seeing that a few other people have joined. Those of you who joined now in the previous few minutes, you just have to add your student numbers into the chat function for us, please. You just have to add your student numbers into the chat function. Okay. I'm going over to example 2. Okay. I'm going over to example 2. And in example 2, we're going to look at inductive reasoning. Okay? We're going to look at inductive reasoning, and in terms of this form of argument, okay? The second, I'm on page 66, paragraph B. The second form of argument, one which may be seen to be the opposite of deductive reasoning, is inductive reasoning. Here the form is the same as for deduction, but the conclusion contains something new. Okay, something more in that it goes beyond the premise. Okay, so let's look at the first example that is given to us. So in deductive reasoning, okay, the premise forces the conclusion on us. Okay, please be mindful of that. In deductive reasoning, the premise forces the conclusion on us. But in terms of inductive reasoning, okay, the conclusion contains something more, something that goes beyond the premise. Okay, so let's look at the first example. It tells us, on the ground of some observations, scientists make claims that cover all future instances. Okay, so water boils at 100 degrees centigrade. Okay, all objects gravitate to the center of the earth, and also dreams have deeper meanings. Okay, the problem then is how premises can still be seen as grounds for a conclusion when there are a number of possibilities. Okay, so to make this clearer, okay, we're going to look at the example on page 67. Okay, now firstly, students, who can tell me what is your understanding of the concept of bail? Can someone explain to me quickly what is your understanding of the concept of bail? Anybody? What is your understanding of the concept of bail? Anyone? What is your understanding of the concept of bail? Michelle, a refundable guarantee of an appearance in court when paying bail can be seen as some sort of admission of guilt. No, Genevieve, bail is not an admission of guilt. Okay. Anyone else? SIPO, a conditional release. Okay, SIPO, you can't, SIPO, you cannot play around with the terminology, okay? You can't have a conditional release of a defendant when we speak of a criminal matter. Okay, you speak of an accused person. Okay, bail is given to an accused until the court date or appearance. It's based if the accused is a flight risk or risk of or risk to society, and it is refundable. Joy, you're on the right track. Stefan agrees with Michelle. What did Michelle say? It's a refundable guarantee of an appearance in court. No. No. No, no, no. Denzel, the accused is set free, so to say, until the next court appearance. Monetary guarantee is revoked if non-appearance. Okay, Denzel, I'm happy with your answer also. Okay, so basically with bail, okay, you should be mindful, and this is what you're going to be doing in criminal law, students. You should be mindful that in South African law, we have the common law principle of the presumption of innocence. Okay? And this is a rebuttable presumption. And this presumption basically means that every accused person, okay, if you are accused of committing a crime, every accused person is presumed to be innocent until proven guilty in a court of law. Okay, that's why bail, okay, because our law is based on this presumption of innocence. Okay, bail cannot be a privilege. Okay, bail is regarded as a right. Okay, so every accused person has the right to a bail application. Okay, every accused person has the right to a bail application. But in terms of the bail application, as some of you have said, okay, in terms of the bail application, as some of you have said, the court, students, just give me a second, I need to sneeze my nose. Okay, I'm back. So, where was I now? So I said every accused person has the right to apply for bail. Okay, it's a right, and Nadia is saying bail is presented to an accused depending on the case. Okay, if bail is not granted, an accused, Nadia, no. Okay. Nadia, you were a bit off track. We'll discuss your comment in a while. Okay. So I'm saying that bail is not a privilege. Bail is a right. Okay, based on the presumption of innocence, every accused person has the right to apply for bail while his or her trial is pending. Okay, but what now happens is that the court needs to consider certain factors. Okay, so it's not like the example where we could prove by premise 1, premise 2, premise 3, premise 4, premise 5 that Abel had sex with Barbara. Okay, so you cannot draw the conclusion when it comes to deductive reasoning. You cannot immediately draw the conclusion that Abel will get bail. Okay? You cannot draw the conclusion that Abel will get bail, even though bail is a right. Okay? Why? Because the court has certain criteria or certain factors to consider. Okay? Now, my next question to you is, when the court, okay, considers these factors, okay, what power or what right is the court exercising? Okay, when we take a bail application as an example, when the court has to consider certain factors into granting bail or not granting bail, what power is the court using? Anyone? What power is the court using? Anyone? Michelle, I want to know specifically what power the court is using. Stefan, no. Anyone else? Some people, it's another simple question like the previous one I posed. Stefan, you're on the right track. What is that judicial power called? Stefan, you're on the right track. What is that judicial power called? Stefan, what is that judicial power called? Anyone? No, not the inherent power. is, okay, remember the court has to consider certain factors or criteria when considering bail. Okay? So when the court considers these factors, what power does the court exercise? Not inherent power, not a constitutional power, Stefan, not precedent, not judicial precedent. Come on, people, it's a simple question. Who's the person who gave me that first answer? What's his name? Karabo. Karabo, can you help us out again? No. Guys, the court uses discretion. Okay? The power the court uses is discretion. Okay? Discretion. So, when the court considers whether an accused person must be granted bail, yes or no. Okay? There's certain factors the court considers. So when the court considers these factors, okay, the court applies its discretion. Okay? The court applies its discretion. That is why, in terms of inductive reasoning, people, in terms of inductive reasoning now, it means that the conclusion, we can't determine the conclusion. The conclusion will have something more in that it goes beyond the premise. Okay, so let's look at the example of a bail application. Okay, so example 2 tells us the following. Let us assume that Abel was arrested. Okay, look at the example. Let us assume that Abel was arrested on suspicion of raping Barbara and now applies to court for bail. Okay? And it tells you here, bail is a court procedure whereby a judge or a magistrate may release an arrested person from custody on the payment of a sum of money. Okay? And look at what the court will look at. The test the court will use to decide whether to release Abel on bail or not is in whether releasing him or not is in the interest of society. Okay? So the court must, okay, it's peremptory. Here the court doesn't have discretion. The court must consider whether it's in the interest of society to release an accused person on bail. Now, what are the factors the court needs to consider? Okay, factor number 1, will Abel return to court to stand his trial? Okay. Factor number 2, okay, will Abel interfere with state witnesses? Okay. Will Abel be a danger to society if released on bail? Will Abel's own life be in danger? Okay, so to decide whether Abel should be released on bail, the court will look at the evidence supporting the above. Okay, after hearing the evidence and argument, the court will ask the following. If Abel is released on bail, is it probable that he will stand trial? What will the court exercise now? It's discretion. Okay? If Abel is released on bail, is it probable that he will interfere with witnesses? Okay? Again, the court will apply discretion. But what is this discretion based on, people? Okay? What is this discretion based on? If Abel is released on bail, is it probable that that society will be in danger? The court will again apply its discretion. And if Abel is released on bail, is it probable that his own life will be in danger? Okay? So the court will apply its discretion based on what, students? Based on what will the court now apply its discretion? Anyone? Thank you, Karabo, on the evidence presented. Thank you, Joy, on the evidence presented. Okay, so the court will apply its discretion on the evidence presented. So here we can see when it comes to inductive reasoning, okay, you can't force a conclusion. Why? Because something new might come up, okay? Or something more that goes beyond the premise, okay? Now let's look at something new, okay, coming up. Let's look at something new coming up. It says here, further in the example, if, for example, evidence is led that a mob of 30 armed men is waiting outside the courtroom, threatening to kill Abel as soon as he is released on bail, the court may reason as follows. Premise 1. A group of 30 armed men is outside the court. True. Premise 2. Many members of the group are uttering to kill Abel. True. Conclusion. Is it therefore probable that Abel's life will be in danger if released on bail? Okay, so the court does not know for sure what will happen, but there is a probability that Abel could be killed and therefore he should not be released on bail. Okay, students, does that make sense? So what I want you to do is, and this I'm going to touch on during our revision session, okay? You comprehensively go through all the aspects, okay, on your own. You comprehensively go through all of the aspects of logic, deductive and inductive reasoning. You go through all of that, and then if there are any issues or anything you don't have clarity on, I will touch on it during our revision session. Okay? Any questions before I continue? Any questions or any comments before I continue? Ask them now. Any questions or comments before I continue? Ask them now. Okay. So if there's no questions, I'd like you to go to page 70 for me, please. If there's no questions, then quickly go to page 70 and we're going to chat or speak on the last paragraph on page 70, okay? Okay, are all of you on page 70? So on page 70, I want us to go to the last paragraph of that page, and we are going to look at the procedural stages of a trial. Okay, and I touched on this aspect in ILW last night. Okay, I touched on this aspect in ILW as well. So we are going to look at the procedural aspects of a civil matter. Okay. Before I start with this, I want to ask you a few questions. How many types of civil matters do we get, students? How many types of civil matters do we get? How many types of civil matters do we get? Okay, Balisa, 2 types. Balisa, were you part of last night's class? Yes or no? Okay. Balisa, can you name the 2 types of civil matters for me, please? Thank you, Balisa. Yumna, if you are not satisfied with the way I'm conducting this chat, you are welcome to leave. Okay, I don't like the comment you made. If you don't like the way I'm conducting this class, please leave the chat. Okay? Okay. Balisa, 2 types. Yes, there's an application procedure and an action procedure. Now, I want you to look at the example at the bottom of page 70, and then we are firstly going to look at the procedural aspects of an action procedure. Okay? We are going to look at the procedural aspects of an action procedure. Now, who can tell me before I continue, what are the pleadings which an action procedure commences with? What are the pleadings an action procedure commences with? Students, what? Okay, that is, you are referring to an application procedure. Okay. Michelle, you are correct. A summons and what else? Okay, so it's our summons and what else? Okay, it commences with a summons and what else? And the particulars of claim. Thank you. Thank you, Terence. So it's our, in an action procedure, it's our summons and our particulars of claim. Okay. Students, in an action procedure, okay, who are the parties to an action procedure? Students, who are the parties to an action procedure? Very good. It's the plaintiff versus the defendant. Okay. Our parties to an action procedure are the plaintiff versus the defendant. Okay. Next question. What is the basis for an action procedure? Who can possibly tell me what is the basis for an action procedure? What is the basis for an action procedure? What is the basis for an action procedure? Michelle is saying, if the rights are infringed, okay. I'm going to explain it to you very simply, so you can take some notes. Okay, in an action procedure, we have one party, namely the plaintiff. Okay. What does the plaintiff do? The plaintiff alleges damage, loss, or harm suffered. Okay. The plaintiff now alleges, I have suffered, I or my property or whatever, I have suffered loss, damage, or harm. Okay, and I further allege that the cause of the damage, loss, or harm suffered was as a result of the action of the defendant, the action or the conduct of the defendant. And I am now approaching the court to seek relief. Okay? Going to say it again. In an action procedure, we have one party, namely the plaintiff, who now alleges damages, loss, or harm. And plaintiff further alleges that the damage, loss, or harm suffered was due to the actions or conduct of the defendant, and plaintiff now approaches court to seek relief. Okay, students, do you all have that? Does it make sense? Who is not clear on that? Okay, you all have that? Okay, so Nadia, I'm going to discuss this with you in our, I think I missed our session on Friday. I'm going to discuss this with you in our individual session. Okay, you just have to now fill out the query form. Okay. Okay, Stefan, the claim is founded in the particulars of claim. Okay, the basis of the claim is all set out in the particulars of claim. Okay, so Nadia, again, we have two parties. One party is the plaintiff, one party is the defendant. And plaintiff is alleging that he or she has suffered damage, loss, or harm. Okay, so damage, loss, or harm, an example is damage to my vehicle of 100,000 Rand. Why? Because defendant negligently drove into my vehicle. Hence, I suffered harm or loss of 100,000 Rand. Now, I'm going to court to seek relief against the defendant. Does that make sense, Nadia? Okay. Now, my next question. In an action procedure, okay, I'm typing it into the chat function for you. In an action procedure, who is the party that is in an action procedure? Who is the party that is dominus litis? In an action procedure, who is the party that is dominus litis? Anyone? Okay. Here are about 5 people who gave the answer. Okay, now my question is going to be, why is the plaintiff dominus litis? Why is the plaintiff dominus litis? Anyone? Why is the plaintiff dominus litis? Okay, SIPO, very good. They are the party alleging. Okay, they are the party alleging. Okay, now my next question. Okay, my next question. What does it mean to be the party that is dominus litis? What does it mean to be the party that is dominus litis? Okay, Denzel, that is not the answer I want. SIPO, that is part of the answer, but it's not the answer I want. What does it mean to be dominus litis? Anyone? What does it mean to be dominus litis? Plaintiff is obliged to, Nadia, that's part of it. That's not the answer I want. Andrew, someone with a real interest in the matter now. Paris, your answer is good, but it's part of the answer. Okay. Okay. Yumna, you are giving me the closest correct answer. You are giving me closest to what I want. Okay. So, what does it mean to be dominus litis, students? Being dominus litis is you are in charge of proceedings. Okay? When you are the party who is dominus litis, you are in charge of proceedings. Meaning you are the party responsible to provide evidence to court, as some of you guys have said now. You are the party who must lead proceedings, hence you must provide evidence to court to prove the liability of the defendant. Meaning, as the party being dominus litis, the burden of proof rests upon you. Okay? The burden of proof rests upon you. And you will notice that in an action proceeding, the plaintiff is cited first. Okay? It's plaintiff versus defendant. So normally the party we cited first, okay, that is the party in charge of proceedings. And very, very importantly, if you are in charge of proceedings, you bear the burden of proof. Can you repeat that? The party whom is regarded as dominus litis, that is the party who bears the burden of proof. Meaning, in an action procedure, the plaintiff has to prove the defendant's liability to court. Okay? And if we now look, yes, Denzel, he controls the proceedings, he's in charge of proceedings. So let's see what it means to be in charge of proceedings. Okay? So if you look at the procedural flow of this action procedure, you will see the opening address is done by the plaintiff, meaning the plaintiff is the party who addresses court first. Okay, only after the plaintiff has addressed court, the defendant will have an opportunity. Okay, meaning there it shows you clearly that the plaintiff is dominus litis, in charge of proceedings. If you go to page 71, okay, when it comes to presenting the case, again, the plaintiff is leading examination in chief. Okay, only after the plaintiff has led examination in chief, okay, the defendant may cross-examine. Okay, after cross-examination, the plaintiff may elect to re-examine, and then after all of that, the plaintiff will close their argument. Okay, only after the plaintiff's case has been presented, the defendant now gets the opportunity to examine in chief. Then the plaintiff has the opportunity to cross-examine. Then the defendant may elect to re-examine, and afterwards the defendant may close his or her case. In terms of closing arguments, again, you will see it's plaintiff that presents closing argument first, and after that, the defendant presents closing argument. Question, student. What rule is applied here? If you look at the procedural flow of the action procedure, I'm looking for a Latin term. What rule is applied here? Okay. Students, I need the Latin term. In terms of the procedural flow here, as we went through it now, okay, what rule is applied here? Come, students. I'm looking for a Latin term. What rule is being applied here? Anyone? Come, students, I'm waiting. Thank you, Michelle. Very good. The Audi Alterum Partem rule. Okay. And what does that rule say? That rule says, hear both sides of an argument. Okay. The rule says, hear both sides of the argument. The Audi Alterum partum rule. Okay, Michelle Forbes, very, very good answer. Okay, so students, I want you to fully familiarize yourself with the content of page 71, 72, 73, and 74. Okay, fully familiarize yourself with that, and then we will briefly discuss all of this next week before we go on to learning unit 5. Now, we did the parties for an action procedure now. Who can indicate to me, or who can tell me, who are the parties in an application procedure? Who are the parties in an application procedure? Okay, I have a response from Michelle. Okay, Sipa and Karabo are saying it's the applicant and the respondent. Michelle is saying ex parte. Michelle, what do you mean by ex parte? Michelle, what do you mean by ex parte? Michelle, you can either talk to me or you can type it into the chat function. Michelle, what do you mean by ex parte?
Good evening.
Hi, Michelle.
Hi. No, I made a mistake. But ex parte is when you have one person applying to the court.
Can you give me an example?
Yes, it would be when you apply to be admitted as an attorney or an advocate.
Okay, very good. Thank you, Michelle. Michelle, where are you from?
Cape Town.
We're in Cape Town.
Bellville.
Are you in Bellville?
Yes, close to Tiger Valley.
Okay, Michelle, then we are neighbors because I'm also close to Tiger Valley.
Okay.
So you must come visit me for coffee one day. Okay, Michelle, good answer. Okay,
thank you.
So thank you, Michelle. Okay, students. So what you should be mindful of in terms of an application procedure is that an application can be brought by one party. Okay, Michelle, you just need to turn your mic off. And this one, you need to turn your mic off, please. Okay. As we saw in the action procedure, in an action procedure, there's a minimum of two parties. Okay, there must be a plaintiff and there must be a defendant. In an application procedure, there's a minimum of one party. Okay, so when one party brings an application in his or her own name, we refer to that as an ex parte application. Okay, but when there's more than one party, we refer to the applicant versus the respondent. Okay, and then, yes, Michelle, it was someone else. Okay, the applicant versus the respondent. Okay, and in that application procedure, where we have the applicant versus the respondent, the applicant is the party being regarded as dominus litis. Okay, students, my last question. In a criminal matter, okay, first part of the question, who are the parties to a criminal matter? If we look at the rape charge of Abel is charged for the rape of Barbara. Okay, if we look at that scenario, who are the parties to a criminal matter? Nadia, very good. Denzel, very good. Joy, very good. Palisa, very good. Michelle, good. Okay, the state versus the accused. The versus the accused. Students who will be regarded as dominus litis, who will be regarded as dominus litis. Okay, the state is dominus litis. Thank you. Okay, now listen carefully because I am going to give you some homework. Okay, you can submit this homework to me by today's Tuesday, by Friday afternoon 4 p.m. Okay, I will put my email address into the chat now. You can submit this written work to me by Friday 4 p.m. Okay? I told you that in terms of being dominus litis, the party that is dominus litis must prove either liability to the court in terms of a civil matter, or they must prove guilt to the court in terms of a criminal matter. So we know that the party which is dominus litis bears the onus of proof. Okay? The party which is dominus litis bears the onus of proof. Okay, but the standard of proof the court relies on, the standard of proof the court relies on in a civil matter or in private law, it's on a balance of probabilities. Okay, in a criminal matter, it's beyond reasonable doubt. Okay, the standard of proof in private law is on a balance of probabilities, and in criminal law, it's beyond a reasonable doubt. So I want you to discuss for me what is the difference between the two standards of proof. What is the difference between a balance of probabilities and beyond a reasonable doubt? Please discuss that, explain it to me critically, and submit it to me. Okay, I am going to put my email address into the chat function. And then my last announcement is, those of you who did not put your student number into the chat function, please do so. Put your student number into the chat function, and you need to complete the feedback or the evaluation form. Okay, students, I am about done. Are there any questions or comments for me before I log off? Any questions or comments before I log off? Ask them now, pose them now. Any questions or comments before I log off, students? Any comments before I log off? Michelle, okay. Ask your question.
thank you. I was just reading through under inductive reasoning, they speak about under point 1, argument from so-called law. I didn't understand what they meant by behavior of people referring to law-like pattern. Can you give me an example of that? That argument from so-called law.
Okay, I won't be able to give it now, okay. Because it's going to take a few minutes. Okay. So what I'll do is when we're back online on Tuesday again, I'll start my introduction with that.
Okay, fine. Yeah? Thank you.
Okay, so if you can't wait till next week, sorry, Michelle,
I can wait
till next week, then you can schedule a one-on-one with me. So you decide. Yeah?
Okay, I'm going to schedule a one-on-one for some other stuff. So could I just raise it then? Or must I schedule it based?
That's fine.
Okay,
no,
thank you.
That's fine. Then you can just raise it. Yeah? Okay, Michelle.
Thank
Nadia, what is the difference between balance of problem? Yes, you need to discuss that for me. Okay, you got that, Nadia? Okay, so if there's nothing else, students, I am going to log off. There are no other hands up. So students, thank you for the discussion tonight. You are welcome to arrange a one-on-one session. I am in the process of returning your written work to you. So just be a bit patient. All of it will happen in this week. And then I will be online again on Saturday morning when we speak on the law of persons. Students, have a good evening. Thank you and good night.